Welcome back to the new episode of TMT with Mike O'Reilly. My guest, Jennifer Huddleston, the Senior Fellow for Technology Policy at the Cato Institute. Thanks for joining us. You've been an outstanding commentator on really important issues in technology policy, and we want to get your thoughts on a bunch of issues before us today.
Thanks for having me. Looking forward to a great conversation today.
How did you get to, let's start with something easy. How did you get to Cato, and what background led you to these issues?
So I've been working on tech policy issues, particularly related to the intersection of law and technology, since I graduated from law school in 2017. I've spent most of that time at various think tanks looking at issues like antitrust, data privacy, online speech, and particularly some of what we've seen in terms of how the light touch approach to tech policy has really allowed America to flourish when it comes to the tech space and what that has meant for consumers as a whole. I do think particularly relevant to some degree to the topic we're going to discuss today. Right after college, I did Teach for America in a third year in a charter school. So I spent time teaching upper elementary and middle school. And one of the reasons that I have an interest in technology not only comes from my time being interested in issues like free speech, but also from the fact that I taught in the Mississippi Delta. And I think about how much technology can empower people in places like the Mississippi Delta with new opportunities, both to express themselves, as well as the economic opportunities technology brings, as well as the opportunities it may mean for teachers in the classroom like myself at that time.
Fascinating stuff. I didn't know that about you. That's really impressive. So have you found, at least in my perspective, that the technology issues have kind of ebbed and flowed in terms of popularity among policymakers? At the moment, technology companies are not really favored. Is that a surprise to you, given everything that's happened?
It's interesting to me because I think that we haven't necessarily seen an ebb and flow in terms of interest, but we have seen kind of a rise in animosity at times towards technology, when at the same time we've experienced some of the most benefits of technology. When you think back to 2020 and the COVID-19 pandemic, when all of a sudden millions of us were working from home and doing school from home in a way that wouldn't have been possible even 2 decades before, that it really was technology that allowed us to stay entertained, to stay connected to friends and family. And yet, as we've started to move back to a hybrid world, as we've started to also see a lot of these benefits and new technologies come about, we've also seen a lot of criticisms of technology, despite it having really given us so many opportunities, both economically and for expression. At the same time, I think particularly in the time I've been working on tech issues, there has been an improvement in awareness and knowledge of technology and technology policy, and perhaps even how some of these policy changes could impact everyday citizens' lives, not just big companies. The fact that, now policymakers and the public are familiar with the law Section 230, or at least tend to think that they know what that means, or that they know something like net neutrality, whatever their position on it is something that I think has really piqued the interest in kind of these broader conversations. And one of the things I like to try and do with my work is really explain to people why you should care about tech policy when you have all these other issues, some of which sometimes may seem more pressing. Why, if you care about speech, if you care about our future, you should want to continue an approach that allows innovation to flourish.
So let's dig into a particular subject matter. The Supreme Court just held oral arguments on a case involving age verification mandates from the state of Texas. And the intent is to prevent children from being access to, I would say, pornographic material, or maybe it's obscene material. That we can get into that more specifics. Can you set the stage for how the oral arguments went, the players, and who was all involved?
Yeah. So as you mentioned, the Texas law that's currently under challenge is an age verification law for websites that carry more than 30% of content that is deemed unsuitable for minors. And so it's a bit broader of a definition than just what would be considered under a traditional obscenity or pornography definition, although it is related to sexual material. This law would require age verification for anyone who wants to access those websites. And I think it's important to stop and think what age verification actually means. This doesn't just mean putting in your birthday or quickly, showing a store clerk your driver's license. It's going to mean uploading some sort of government document, usually, to a website in order to access information that an adult has the right to access under the First Amendment. Now, the Texas law, as I mentioned, is a bit broader than just things that are traditionally seen under an obscenity definition. And it applies to content of a sexual nature that's deemed unsuitable for minors. But it doesn't really distinguish between the 3-year-old and the 16-year-old, the way that your average household probably would. So one of the concerns with these proposals is, while there may be some good intentions behind the state wanting to protect young people from pornographic content, that it has a real significant impact on adult speech rights. But there's also this question of, particularly in this law, is it broader than just even that type of content that previous cases may have said that people under a certain age don't have the same right to access as adults do? Is this the type of thing that, because of the threshold, because of the definition, could see sexual health education websites caught up in it, or even much more general purpose websites that just find a sudden amount of spam on them? So if X or Facebook or Truth Social gets spammed by a bad actor with a lot of pornography all of a sudden, or with inappropriate images, could they then be subject to the Texas law very quickly? These were the type of things that came up at oral arguments. The plaintiffs in the case are bringing it on behalf of adult content websites, but there are amici who are not adult content websites, and there's been a lot of conversation around these types of laws, not just for adult content websites, but we've seen states looking at even applying age verification more generally to the internet through things like social media.
So this wasn't actually, or arguments were not on the constitutionality of the state statute. It was on the Fifth Circuit's review and potential, preliminary injunction that was issued, and whether they used the proper standard. Do you believe that when the court answers that question in some form or fashion, it will provide insight on the bigger picture, or do you think it'll be fairly narrow on what they should do what the Fifth Circuit should do?
This seemed to be kind of the conversation the justices were having amongst themselves during oral argument. So as you mentioned, to get kind of really legal wonky here for a minute, the district court granted an injunction, then the Fifth Circuit removed that injunction. What's actually on appeal is not the constitutionality of the law, it's whether that injunction should be put back into place. A lot of the questions were going to the underlying question of, how should laws like this be analyzed? Should they be under strict scrutiny, or as they impact the rights of adults, or should they be under a more rational basis standard as relates to the rights of minors to access this kind of material, potentially going to a couple of divergent cases there. The court seemed to really struggle with, do they need to reach that underlying question of what kind of review does this law deserve? Has technology, has the market changed in such a way that some of the earlier internet era cases that struck down laws around age verification or around similar restrictions on online content need to be reconsidered? Or is it something where strict scrutiny still applies to these laws, and do they even need to get to that standard? Or can they just say, the Fifth Circuit didn't correctly consider the preliminary injunction, we're reinstating the preliminary injunction, and then the Fifth Circuit can later determine the underlying question of kind of constitutionality under strict scrutiny or other standards as appropriate?
You started to talk about and went through some of the age verification mechanisms. What documents are eligible under the state of Texas, and are there concerns about that material being captured and maybe having security leaks? We deal with some cyber attacks on lots of different scenarios these days. Is there concern that could be exposed material going forward?
You know, there's a great line, and I'm gonna paraphrase it here during the oral arguments, where it's something like, everyone knows hacks happen, or everyone knows breaches happen. And so that's one of the questions, is that this is potentially content about someone's sexual preferences or sexual history, that you are requiring someone to create a record of their accessing it that could create greater vulnerabilities, and potentially could even, in some cases, be accessed by a state if they have concerns about that. But I think in order to talk about that, we first have to talk about what makes the Texas law a bit different from some of the other laws that we've seen. So there have been age verification laws for these kind of adult content websites in Utah, in Virginia, and in Louisiana. Sometimes you'll jokingly hear them referred to as porn passport laws, which sounds a little silly when you say it. But if you actually take a step back and think about it, it's kind of accurate. The idea is that in order to access pornography online, you'd have to show your passport. You have to show some sort of official government document that proves that you are who you say you are. So that may mean a driver's license, a passport, a birth certificate, something that verifies your identity and your age, and that typically that has to be stored by the company for some period of time in order to ensure compliance with the law, so that if they're questioned about someone underage, they can say, well, they at least presented significant information where we have a defense there. Some advocates for these type of laws will point to the idea of facial recognition scans or of age assurance rather than age verification. And this is the idea that kind of you go to the grocery store, and based off of what you're buying and the way you look to the store clerk, they assume that maybe you're over 25, so they don't ID you for the bottle of wine kind of thing. That rather than checking it, they're basing this on a history of knowing you or of what your appearance looks like. And so they don't actually verify it. They base it on all these other facts. But in order to do that on a website, you're going to have a couple of more sensitive pieces of information. So that may mean looking at someone's credit card transactions, for example, to determine, are they behaving the way an adult behaves? Looking at their online history, so something a bit more privacy invasive, to say, oh, does this search, do these interactions look like an adult? Or again, scanning biometrics, which has its own privacy concerns for a lot of individuals, although biometrics can be a very useful tool. But particularly when we think about the biometric scan, which is usually the most commonly pointed to alternative to kind of showing IDs, no biometric scan exists, at least to my knowledge and to other experts that I've talked to's knowledge, that can tell the minute someone turns 18 on their birthday. And the reason that matters is that means you're still going to have people doing these other elements that are very potentially privacy invasive, that create that potential cybersecurity risk, even if you're also doing the biometrics in order to actually verify the ages. Because either you're going to have a swath of people that are entitled to access that don't have access, you're going to be worried about giving underage people access when it's illegal, or like I said, you're still going to have to complete that. Okay, maybe we can guess they're between 17 and 19, but if 18-year-olds have access and 17-year-olds don't, then you're going to still have to have a method of verification.
The oral arguments, when I listened to them, seemed to suggest that the court was struggling between wanting to provide protection for children, but also their age verification or their age precedent, and what they've done in the past. Is that a fair take?
Yeah, so there are really two cases that seem to be potentially at tension here, that the court was trying to struggle with, both to figure out which case it might more resemble, as well as how to perhaps consider these precedents together. One is a case called Ashcroft that has to do with prior attempts for age verification online and the constitutionality there. And in that case, the court really pointed to the availability of filtering software and things in order for parents to feel empowered. No one is saying that you have to let your child unsupervised on the internet with all risks. The question is there a compelling state interest such that we can potentially restrict the speech of adults in order to achieve this protection in a least restrictive way? Or are there other things that the state could do to encourage parents to use filtering software if they're concerned? Or, for example, provide education or alternatives to help people who may be wanting to avoid certain types of content, or have better education in schools about internet safety practices and things like that. The other case is a case called Ginsburg, and that case had to do with the sale of pornographic material to underage individuals. And the distinction there that was that it was about the rights of the minors themselves as opposed to the rights of adults to access it. So a lot of the debate in the oral arguments seemed to be, is this actually about adults' rights to access, where we have that kind of least compelling standard, or I'm sorry, that where we have that least restrictive means compelling government interest standard. You know, we've considered all the alternatives, we've considered the privacy trade-offs, things like that. Or is this more like the Ginsburg case, where we're actually talking about the rights of the minors themselves? We're talking about something that is really only aimed at impacting the young people and their rights to access this type of information, and particular potential restraints there that would be analyzed under a much lower standard.
The court seemed to struggle with the issue of obscene material, as you just described. Is obscene to whom? Is it the younger kids or adults? How did the court, how does the court deal with the fact that much content can be illegal? It's maybe indecent, but it's legal for adults to access, and their rights to that under the First Amendment.
And I think this really goes down to that question of, when we're talking about adults' rights in this case, is this the least restrictive mean given all those privacy concerns? Is this the equivalent of making, one of the sets of questions was kind of, is this the equivalent of saying strip clubs must force people to show IDs to enter? And it was largely seen as, no, this is much more invasive. This is creating a record. This is creating a record about potentially sensitive information. This is not just a quick check and, the store clerk's not going to remember who you are 2 weeks later, type of situation. This is something that is requiring potential record keeping and that potential sensitivity to access information you may be entitled to. Some on the court seemed skeptical of the fact that this was only being brought by adult content websites, that it wasn't also being brought by some of these other groups or websites that the plaintiffs and others have said might be impacted as well. The idea of, given some of the broad descriptions in this, could this impact particularly women's reproductive information? Could this impact certain things that are not quote unquote hardcore porn, but might have descriptions that don't meet the artistic exception in the law? And so that goes back to one of the quotes at oral arguments was kind of, this is the worst version of this law, is what the plaintiff said, of that this is kind of the broadest description, the broadest potential application, which means it could have the greatest impact on speech. And it's not occurring in a vacuum. It's occurring at a time when we're also really seeing these kind of age verification laws pop up not only in various states in the US, but around the world, that would impact speech online more generally. They're not just aimed at certain types of content, where there can even be disagreement among individuals about what age certain types of content are appropriate for, or what information is or is not harmful to a young person. So you can imagine that the state of Texas and the state of California might disagree on some issues of what information around sensitive topics is or is not appropriate for young people at a certain age. And that can very quickly create conflicts that make it impossible to either have important conversations online, or for particularly smaller platforms to know what the rules that they have to apply are.
There seems to be sympathy to the fact that content is widely available these days, that there's been an explosion of material, and that the plethora of technology in throughout the nation at different ages is available. But that's not the first time we've seen technology develop and explode, right? This is not a novel idea.
No, in fact, young people are often early adopters of new technology, and we've seen a lot of concerns about whether the kids are okay with any new technology, whether it's, today's concerns about smartphones, or there's a lovely X feed that I enjoy called Pessimist Archives, and it pulls these headlines from back in the day of all of our technological fears. And one of my favorite ones is about how kids are reading too much, and how the dime store novel is rotting away a generation's minds. And you feel like you could play Mad Libs with some of these things and just replace smartphone for dime store novel or comic book, and you would get a very similar reaction. So the fact that we have concerns for the next generation and the content they may be consuming are not new. But I say that not just because it's a good laugh of, are the kids reading too much today, but because you can imagine what would have happened if we had tried to stop the novel. Instead of being this wonderful tool for expression and storytelling, we would immediately jump to that kind of concern. When we're seeing around concerns around technology today, I think a lot of times they are reflections of these underlying concerns that we've long had just with a new tool at hand. Being a parent today is hard. Being someone who cares about young people, whether it's a parent or a teacher or an aunt or an uncle, means that you're going to have them encounter a lot of different challenges. And there are tools already out there, whether they're built-in tools in a device, whether they're tools that an individual platform offers, or whether they're tools that a parent can add on that really enable different families to come up with different solutions. But even within the same household, you may have different concerns. Parents may be concerned about one child accessing certain types of content, while another child, they're more concerned about how much time they're spending on their device. So when we look at this in a policy framework, it's not a one-size-fits-all solution. And policy is typically a one-size-fits-all tool, which is why the focus should be more on education and empowerment rather than on regulation itself. And we saw this was an argument that was really put forward. Like, look, the tools are out there. This has been put forward when we look at the early internet era cases. This is put forward in this case as like, there are alternatives for the people who want to help avoid this. There were some conversations on the court of, is it too overwhelming? Is it too much? But I don't think that should be an excuse for the state to step in. Because it's a hard decision, it takes a lot of work, doesn't mean that there's not a less restrictive means out there.
You described my household very well, I can tell you. But the Biden administration Solicitor General said basically that the Fifth Circuit erred in their analysis for the preliminary injunction. Do you think that the change in administration will have impact, not necessarily on this immediate case, or they could possibly, but in terms of how it approaches this exact issue if we get to if the court returns to the substance of the matter?
It'll be, a bit hard to predict. We have seen calls for age verification from both Republicans and Democrats. I would hope that there is an understanding of the impact that could have on speech and on various voices, and particularly on the way that we have seen young conservatives really use social media as a tool to express themselves. You may not think about it with this particular law, but when you look at some of the other laws that are out there on age verification, that have been much more broad in terms of where they would apply online, when you look at what's going on in places like Australia, when it comes to social media regulation, if things like that were to come here, I would hope that there's an awareness of how powerful these platforms have been for all voices to be expressed, including those of young people, and that we would see a similar kind of pushback in the current administration.
Were you surprised that the Biden administration Solicitor General almost seemed to suggest that this law was too much, but really wanted the court to either provide guidance or some kind of path to allow age verification to move forward? That they were begging the court that you didn't have to go that far and rule out age verification as it relates to inappropriate material.
So this is one of the really big questions that this case seems to have teed up. And at times it was pretty directly questioned by the court of, can age verification ever be constitutional? And I think one of the real underlying questions there is also, can the technology ever exist in such a way that we overcome what I described as some of those challenges? Could we ever get a technology so precise that you could look at the camera and it could tell you down to the second how old someone is? Now, that probably brings with it a whole nother host of concerns, but the technology doesn't seem to be there as it is now. Similarly, is there ever a way that we could have some sort of encryption or anything like that where there could be a guaranteed safety of this information, or a way where it wouldn't potentially impede individuals' speech rights or things like that? That's what the court's really going to have to grapple with if it wants to consider that question of, could age verification ever be constitutional? And I think this is also where bringing in some of the distinctions in what's gone on with some of the age verification laws we've seen elsewhere around the world and the U.S. is important, in that the U.S. has the First Amendment standard, which means that things that could pass scrutiny in other countries have to meet a different standard in U.S. courts when they're challenged. We've seen, for example, in the U.K., there was some sort of agreement that they wouldn't enforce certain elements of age verification requirements or of their online safety law until it was technologically feasible to do so without violating user privacy. But doing that also kind of raises this question of, how much can you trust a government promise like that versus the actual black letter law on paper? So I think the question of do we need to base the law on where the technology currently is, or do we need to base the law on where the technology could go? Sounds like it's something that the court is grappling with, and that the Solicitor General was perhaps asking for guidance on. Is this is unconstitutional as the technology exists now, but someday it could be? Or is it, this will forever be unconstitutional regardless of how the technology evolves?
And the Solicitor General also suggested, in my read and listening to the oral arguments, was that strict scrutiny should apply in this instance, the First Amendment standard you talked about earlier, but that you could bend strict scrutiny for legitimate purposes, that if it was in the government's best interest, whereas in other instances it may be antithetical, here was something that was in the value of the citizenry, and you could bend it. Is that how strict scrutiny has been treated in the past by the court? Is it something that is amenable based on whether the administration finds it valuable for its purpose?
So it's important to remember that strict scrutiny does not mean that the government automatically loses. It's designed to really provide a high bar for the impact that it could have on First Amendment protected speech. So this could be, it would require a compelling government interest. So one of the questions is protecting young people from obscene content a compelling enough government interest? But then there's a second prong, which is does it achieve that via the least restrictive means possible? Which goes to one of the elements of this case was, is age verification the least restrictive means, or are there other things that can be done? And if so, is it just a choice between age verification and do nothing at all, or are there steps along the way that would be upheld as constitutional because they would be considered less restrictive? Which again probably goes to some of the guidance that perhaps the last administration and the current administration are seeking from the court, is if this is considered not least restrictive, would a different type of behavior be considered to meet your standard?
As an expert in this space, what's your prognosis for where this court goes? And then what's the implication for this particular case, depending on your view?
So I think there are a couple of potential outcomes. The broadest outcome is on either side, and that is that we see a significant ruling on age verification in general, either upholding age verification as constitutional or saying age verification is never constitutional when it comes to the internet, and really upholding some of the prior internet law very strongly that way. I don't necessarily think we will see that broad ruling on age verification in general. The next option would be to see a ruling on the underlying merits of this law, something that really looks at that question of age verification in the adult content space, even though this law is a bit broader. Is it a question of Texas's law is too broad, but if you narrowed out up these definitions type of thing, then we would consider that. I think that's more plausible than the broad age verification ruling in general, that you see something that gets into the question of, is this type of content different? And if so, is this more like Ginsburg or is this more like Ashcroft? And really kind of does not get to the broader age verification argument, but does look at age verification on adult content websites. I think the most likely, though, is that we are actually going to see what ends up being a more legal wonky argument, and that is something around whether or not granting or revoking the injunction was correct. It seems like we've seen a lot of this happen recently. If you look at, for example, the Murthy case with standing, even the Net Choice case, how that was a 9-0 decision on the remand, and then a lot of different opinions on the kind of underlying issue, even though you do have a majority opinion there. I think you could very likely see something that kind of avoids getting into the underlying question of what degree of scrutiny does age verification law deserve, and instead looks at the question on the preliminary injunction grounds.
Switching out of this case specifically, is it your I've looked at a bunch of these cases in last term. Now we're starting a new, the new term has had a couple cases already, including the TikTok case and this case. Do you believe, or is it your experience, that the court tends to balance out its First Amendment, not in terms of having a straight counting? We did 2 over here, we're going to do 2 over there, but it seems to try and, it doesn't seem at the end of a term that one side has won them all. Even if they, Murthy's a great example where I think most people thought it was going to go in one direction and it didn't, but then it was still called the greatest First Amendment Supreme Court in history.
I think it just shows how complicated many of these cases are, that it's not always as straightforward, and that oftentimes, those of us who particularly work on tech issues or speech issues are really interested in the underlying issue, and you actually have this kind of nuanced, wonky element of procedure that may actually completely change what can happen. I would actually point to something like the Gonzalez v. Google and Twitter v. Tamna cases, where a lot of people were really expecting some kind of major ruling on Section 230 and algorithms, and instead you had something that, luckily did not change the underlying law around 230, but was much more about the laws that these cases were initially being brought under than Section 230 itself. And so that always is a possibility when it comes to First Amendment jurisprudence. And I think that what we're seeing is that we are increasingly seeing tech in the First Amendment at the Supreme Court, and that doesn't look like it's going to slow down anytime soon. If you look at some of the challenges going on in lower courts right now, whether it's to these broader age verification bills that I mentioned, or to some cases that are in the post-Net Choice decision era, digging into this question of algorithms as speech and as it relates to AI even, it seems like we're going to continue to have this kind of intersection of tech and speech before the court on a regular basis.
Well, it sounds like you're going to have plenty of work going forward. I can't thank you enough for sharing your insights, and really appreciate everything you've been able to say today.
Thanks for having me.